Whether you have an employment, criminal, family, corporate, or personal injury matter, legal issues can be puzzling. The lawyers at Devry Smith Frank make all the pieces fit together.
Welcome back to Real Estate 101. Today we're going to talk a little bit about what it means to be common law, and I'm pleased to be joined once again by John Schuman of Devry Smith Frank LLP. John, welcome back to the show.
Good to see you again, Joe.
Okay, John, so when are people legally considered to be common law?
Well, it depends on for what purpose. For taxes, people are legally common law when they've been living together consecutively for 12 months, or they have a child together, or they share a child in the same way as if they had a child together. For benefits, you really have to talk to your benefits provider. But since I'm a family law lawyer, I can tell you that for family law purposes, you are common law when you've lived together with your partner for 3 years, or you have a child together by birth or adoption. If it has not 3 years, you don't have a child together, you're not common law yet.
Okay, so is being common law the same as being married?
Well, for tax purposes, and it's very similar, and for benefits, talk to your benefits provider. But for family law, in fact, it's very different. All that common law means from a family law perspective is that you can claim spousal support from your spouse or your common law partner. You can't make a property claim. You don't share in your assets. The only other thing you can do is you can get a restraining order against a common law spouse. But you don't have to wait 3 years for a restraining order. As long as you just slept together one night, you can get a restraining order. But other than that, it's just spousal support.
All right, so has there been any thought about changing the laws to make common law the same as being married?
In British Columbia, they did it, and they made common law basically exactly the same as being married. But that's not the case anywhere else in Canada. And in fact, the courts have said that there's people who choose to be common law are choosing not to have the same obligations as being married. So the courts and most of the legislatures have left it different. If you're getting married, you're getting married. If you're common law, you're not getting married.
Okay, so what happens if two people are together for a while and the house and savings are only in one partner's name? Does that other person lose out?
Yes, they do. Strictly according to the law, if you're common law, you don't share assets. So if the partners put everything into one partner's name, then when they separate, that one partner keeps everything. Now that is really unfair in a lot of situations, especially when you have people together for 20, 30 years and they've never been married, but they've always considered themselves to be a couple, and they've always, put everything together as if it was, everything they had was theirs together, but it only placed in one person's name. In that case, the courts apply these concepts called equity. Now, equity is a concept that exists in the Commonwealth countries because it comes from the British courts. And this is where it makes a real difference to have gone to law school, because equity is not law. It comes from these courts of equity a long time history ago. You don't need to know about it. You need to get a good family lawyer to understand it.
Right.
But in equity, there are these ideas, these remedies that are what a court can do is declare that the spouse who is not the person who owns anything, doesn't have title, the spouse can declare that that person actually is on title. There's like a court order that says that even though title or the name on the bank account says Joe is the owner, you can say that Joe and Jill are both the owners, and that makes them both the owners. And that's how it's remedied. But it's a really complicated thing, and you really need to speak to a lawyer about doing it.
Okay, John, so let's say one partner has an important asset that they don't want to share. Might that be a reason why they choose not to get married?
It might be, and if they really want to protect that asset, then that's the reason why common law couples sign cohabitation agreements. Cohabitation agreements are basically the same type of idea as a marriage contract. They set out the rules and what happens when you separate. And in a cohabitation agreement, you can not only say that no matter what happens, we're not sharing this particular asset, and you can exclude all those rules of equity that I just talked about, but you can also set up anything else. So you can set up that, yes, you will share assets if you want to, or you can set up what kind of support would be paid, regardless of what the Family Law Act would say. So you can really arrange your affairs with a cohabitation agreement.
Okay, John, so you mentioned spousal support. Is it any different in common law than it would be if two people were married?
Not at all. Once you meet the definition of common law, which means you have been together 3 years or you have a child together, then spousal support is calculated exactly the same way for married or unmarried couples. Married couples can have spousal support orders if they've been married for only a week or even less. But for common law couples, you have to be there that 3 years or have your child together, and then spousal support works exactly the same way.
And what about child support? Is that any different?
Child support's not different at all. Child support is for the benefit of the child, and it doesn't matter to the child whether the child's parents are married or common law.
Okay, John, so let's say a couple got engaged but decided to remain common law. What happens with the engagement ring?
Engagement rings are a special sort of gift. They are a gift in contemplation of marriage. That's the legal term. And what that means is that an engagement ring is part of a contract, and that contract is a contract to get married. So one spouse gives the other one an engagement ring, and in return, the other spouse gets married to the first spouse. So if that marriage never happens, then the terms of the contract weren't fulfilled, and the engagement ring has to go back to the person who gave it to them.
Okay, John, so for today's final question, do you have any last tips for any of our viewers that are contemplating a common law partnership?
Know what you're getting into. Common law relationships also have legal rights and responsibilities associated with them. And so I see people who think they're about to become a common law partner, about to get married, and they come to see a lawyer so they understand the legal consequences of what they're doing. And that's the best idea, because then you know going into the relationship what's going to happen if you go out of the relationship at the end.
All right, John, thanks very much for coming on today's show, and I'm looking forward to seeing you again in the future.
Looking forward to seeing you again too.
So if you're having any issues in your common law partnership and need the help of a top family lawyer, get in contact with John Schuman of Devry Smith Frank LLP. I'm your host, Joe Tracera. Thanks for watching, and we'll see you next time.